They took his passport, not suspended, not restricted, confiscated. And according to reports circulating across political and legal circles, the justification included two explosive words: flight risk. Even more striking, the phrase allegedly used internally: flight risk extreme. If true, that changes everything, because when authorities use that language, they're not speculating, they're calculating. Tonight, we break down what passport confiscation actually means under U.S. law, why border systems may have been alerted, what extreme flight risk really implies, and whether this moment represents a legal safeguard or a historic escalation in American politics. Because if a former president of the United States is being officially treated as a potential flight risk, then we are no longer in familiar territory. We are in constitutional gray space. Let's start with the basics. In the American legal system, a passport is not a constitutional right. It's a government issued travel document, and it can be seized under specific judicial conditions. Typically, passport surrender occurs when a defendant is formally charged with serious federal crimes, and a judge determines that pretrial release requires safeguards to guarantee appearance in court. In other words, it's not about punishment, it's about ensuring jurisdiction. But here's what makes this different: we are not discussing an anonymous defendant. We are discussing Donald Trump, a former commander in chief, a former president, a current political figure with ongoing influence, and a candidate in a highly polarized political climate. That context transforms the meaning of every procedural move. Now, let's talk about what flight risk actually means in court. Judges evaluate flight risk based on several factors: access to financial resources, international ties, dual citizenship or foreign residency options, control over private transportations, severity of potential penalties, past compliance with court orders. If prosecutors argue someone is a flight risk, they are essentially saying this: the person has both the means and potential incentive to leave U.S. jurisdiction. The addition of the word extreme would signal an elevated assessment, suggesting that standard monitoring may not be considered sufficient. And here's where capability matters. Donald Trump has access to private aircraft. He has global business connections. He has diplomatic relationships developed over decades. He has international visibility and name recognition that could theoretically facilitate complex travel arrangements. Now let's pause. Is there evidence he attempted to flee? No. Is there confirmation of departure plans? No. Is there proof he violated any court condition? Not publicly. So, if this action occurred, it would likely be precautionary, not reactive. And precaution at this level is strategic. It suggests that legal authorities believe stakes are rising. Historically, no former U.S. president has had their passport confiscated under criminal risk assessment protocols. Not during Watergate, not during the Iran-Contra investigations, not during impeachment proceedings of any administration. Those were political and legal crises, but passport seizure was never part of the equation. So, what makes this different? Several possibilities. First, prosecutors may believe formal charges are entering a sensitive stage. Second, new evidence could have shifted internal risk calculations. Third, court conditions may have been modified quietly, expanding travel restrictions. Or fourth, the move could be designed to preempt speculation, to eliminate even the theoretical possibility of jurisdictional complications. Because in high-profile cases, perception matters almost as much as procedure. Now let's address the reported border alert. If Customs and Border Protection systems were flagged, that would mean any attempt to leave the country would immediately trigger notification protocols. This is not symbolic. This is active monitoring infrastructure. It places the individual inside a controlled travel environment. And here's where it becomes politically volatile. Supporters of Trump are likely to interpret this as escalation, perhaps even legal weaponization. They will argue that labeling a former president as an extreme flight risk is reputationally damaging and strategically timed. They may frame it as a move to influence public perception during an election cycle. On the other side, critics will argue that the rule of law cannot be selectively applied. If risk factors meet threshold criteria, then procedural safeguards must operate regardless of status. That tension between equality before the law and political sensitivity is the core of this moment. Because we are not just debating travel documents, we are debating institutional boundaries. Now let's examine the strategic question. Would fleeing even be realistic? The United States maintains extradition treaties with over 100 countries. Escaping permanently would require relocating to a jurisdiction without extradition cooperation. And even then, diplomatic pressure would be immense. Any nation harboring a former U.S. president would face immediate geopolitical consequences. So, from a practical standpoint, actual flight seems unlikely. But in legal risk assessment, likelihood is not the only variable. Capability plus potential incentive equals evaluation. And that's what prosecutors would analyze. Now, let's talk about incentive. If someone believes legal jeopardy could result in severe consequences, financial, reputational, or custodial, incentive variables increase. The more serious the potential penalties, the more courts consider flight mitigation. Again, this is not accusation, it is standard legal calculus. And in high profile federal cases, courts tend to err on the side of containment rather than leniency. But here's the deeper constitutional question. The presidency carries enormous symbolic weight. However, it does not grant permanent immunity from legal procedure after leaving office. The Supreme Court has historically affirmed that executive privilege has limits and that former presidents remain subject to judicial authority. What we may be witnessing is the stress test of that principle. Because enforcing procedural restrictions against a former president is not just legal, it's institutional. It sends a message domestically and internationally, and that message is complex. To allies abroad, it signals that American legal institutions function independently of political hierarchy. To adversaries, it may signal internal volatility. To voters, it reinforces either faith in accountability or suspicion of overreach, depending on political alignment. Now let's explore timing. If passport confiscation occurred now, why now? Legal strategy rarely operates in isolation. Often, pretrial maneuvering intensifies before major hearings, motions, or evidentiary developments. Restricting travel can serve multiple purposes: preventing sudden diplomatic complications, limiting media optics of international appearances, ensuring uninterrupted jurisdiction during critical procedural phases. In other words, it stabilizes the legal environment, and stability is something courts value highly, but the optics are unavoidable. Passport confiscated. Flight risk extreme. Those words carry psychological force. They suggest containment. They imply risk. And they frame the narrative in a way that transforms a legal process into a dramatic headline. In the digital age, that matters. Headlines shape perception long before legal briefs are read. Now let's step back further. What does this mean for the broader American system? If the legal system is willing to apply standard risk protocols to a former president, it reinforces one foundational principle: no one is procedurally untouchable. But at the same time, such actions can deepen political polarization. Supporters may see persecution, opponents may see overdue accountability, neutral observers may see institutional tension. That's the crossroads. And here's something often overlooked: judges are acutely aware of optics. They understand that every decision in high profile cases becomes precedent. So any move to confiscate a passport would likely be carefully justified under existing legal standards. It would not be impulsive. It would be documented. It would be defensible under statute. And that's important. Because if this escalates further, if pretrial conditions tighten, if additional monitoring mechanisms appear, it suggests prosecutors are preparing for a long legal process, not a symbolic confrontation. Now, let's address the geopolitical layer. International markets react to instability. Foreign governments track U.S. political volatility closely. If internal legal battles appear destabilizing, diplomatic relationships can become cautious. A former president under travel restriction could complicate international appearances, negotiations, or political messaging abroad. That's why this is not merely domestic legal news. It's global signal management. And in geopolitics, perception often influences policy. Now, imagine the alternative scenario. What if passport confiscation is temporary? What if it is administrative? What if it is quietly clarified as routine compliance with court conditions? In that case, the headline impact may outweigh the procedural reality. But even then, the threshold has been crossed. Because once a former president is publicly associated with the term flight risk, the symbolic barrier has shifted. And symbolic shifts matter in politics. Now let's consider the broader pattern. American institutions have faced increasing strain over the past decade. Impeachments, investigations, indictments, public distrust. Each moment tests constitutional resilience. Passport confiscation, if confirmed, would be another chapter in that evolving tension between executive legacy and judicial authority. And here's the key point: this is not about travel, it's about jurisdictional control. It's about ensuring that the court, not political circumstance, dictates the pace and boundaries of the legal process. Whether one views that as protection or escalation depends on perspective. But structurally, it reflects a system prioritizing procedural certainty over symbolic caution, and that is historically significant. Because until recently, few imagined a scenario where a former U.S. president would face the same pretrial travel constraints as a corporate defendant or public official under indictment. We are now potentially in that scenario. So, what happens next? If restrictions remain, expect intensified courtroom dynamics. Expect strategic messaging from both sides. Expect the phrase rule of law to be invoked repeatedly. If restrictions are lifted or clarified, expect accusations of media exaggeration. Either way, the moment has landed. And moments like this accumulate. They shape narratives, they influence elections, they test institutions. At its core, this story asks a simple but profound question: how far does accountability extend? Does it stop at symbolic status, or does it operate uniformly, regardless of title? The American system is attempting to answer that in real time, and the answer will define more than just one case. It will define precedent because precedent is what future administrations inherit. And once a procedural boundary is crossed, it rarely uncrosses. So, as this unfolds, remember there is no confirmed attempt to flee. There is no proof of imminent departure. There is only a reported procedural action that carries extraordinary weight. And that weight comes not from the passport itself, but from what it represents: containment, jurisdiction, and the activation of full legal machinery against someone who once held the highest office in the land. This is not ordinary. It is not routine. It is not insignificant. It is a stress test of American democracy. And whether this becomes a footnote or a defining chapter will depend on what happens next. Stay alert. Because in moments like this, history doesn't announce itself loudly. It shifts quietly through procedures, filings, and decisions that ripple far beyond the courtroom. And this ripple is just beginning.